Good morning, Judge.
Everybody, we ready to go?
Yes,
Oh,
sir.
yes,
We're
Your Honor.
ready.
Excellent. We have a Spanish interpreter matter first. Rhea Garcia. What does the state feels appropriate?
¿Qué es lo que piensa la fiscalía que es apropiado?
Yes, Your Honor, we are still waiting to hear back from the victim in this case.
Sí, su señoría, estamos esperando contactarnos con la víctima en este caso.
And so we would ask for one more day on this case.
Así que vamos a pedir un aplazamiento de un día.
All right, sir, we'll see you tomorrow morning.
Muy bien, señor, le vemos mañana por la mañana.
Yes.
Angles and then Henderson. All right, what does the state feels appropriate on Angles?
Yes, Your Honor, in this case, we are asking for $15,000 bail, as well as no contact with, I believe it's the only address I think I show is 1805 Purdue Drive, which is where the vehicle was located in front of the victim's house. I would also ask for no contact with the juvenile co-defendant J.A., as well as no firearms. The defendant has, although he's only 19, concerningly is pending a jury trial for a felony charge of grand larceny of a firearm. While he committed this act, again, concerning given the witness and essentially the admissions that were made here and the kind of senselessness of this crime. So given the fact that he was already pending a very serious case and we have another felony case here, we believe that bail is appropriate. Thank you.
Thank you. Defense.
Thank you, Your Honor. We understand that being accused of another criminal offense while on supervision is a serious matter. However, Mr. Ingalls has been complying with pretrial services check-ins. He is in contact with his attorney. According to the probable cause sheet, there are a lot of people involved, and so there's at least colorable arguments regarding the level of culpability of Mr. Ingalls. We were trying to reach a reference this morning. Unfortunately, we were not able to speak with her, but he did provide a reference of a friend where he's been staying with a phone number. And so we would ask the court, understanding again that some bail is going to be appropriate, given that he's already on an own recognizance, or excuse me, a pretrial release. We would ask the court to set bail in the amount of $1,000. Even that will be exceptionally difficult for him to post, but it would be sufficient to mitigate his attendance at future court dates, as well as future criminal activity.
So Ms. Raines is right. It's certainly a very serious concern when an individual is arrested while out on pretrial release. In fact, the people of this state, through their legislature and NRS 178-487, have indicated that this is one of the rare circumstances where an individual can be held without bail. Both on this case, while the state seeks to revoke bail on the earlier case. But the state has not indicated to me that they're seeking to revoke bail on the other case and or to hold him without bail on this case. However, it still must be noted, one, his age, two, the community's concern with regards to individuals allegedly committing felonies while out on release on a felony. Therefore, the state shown by clear and convincing evidence that bail outside the defendant's ability to make it is necessary to ensure the safety of the community. The appearance of the defendant will be set at $50,000. No contact with the victim, DA supervision, no bail laws, make all court appearances. November 7th at 9 a.m. will be the defendant's next court date for the arraignment on the criminal complaint. If we get the complaint sooner, we'll see him sooner. Thank you. Henderson and then Himmers.
Oh, Your Honor, I'd asked to waive Ms. Henderson's appearance. I was able to speak with her. She's detoxing this morning.
All right, what is state feels appropriate?
Yes, Your Honor. In this case, we would be asking for $15,000 DAS supervision, testing for alcohol and controlled substances. Defendant has a criminal history going back to 2019. She had a an arrest in Medford, Oregon for theft that I don't show disposition for. Also had a misdemeanor conviction for possession of stolen property in Humboldt County, California. Had a felony conviction for evading a peace officer in Del Norte, California. She had also an arrest for a fugitive from another state and burglary in Jackson, Oregon. I don't show a disposition for that burglary. She had a 2021 felony conviction for felon in possession of a firearm in Josephine, Oregon. Had a transporting a controlled substance in San Francisco in 22 that was dismissed, and then a theft and failure to appear arrest in Jackson, Oregon in 23 with no disposition, as well as a fugitive from another state arrest. She has a few fugitive from other state arrests. I show 7 total between 23 and 25 that appear to be probation violations where she was sent back to I believe Oregon to deal with probation violations. So concerning, given the relative lack of ties to the community, as well as I believe she's this is really her only contacts with this area. It appears that she's got an Oregon vehicle. And so we believe that bail is appropriate. We would also ask for a stay in Northern Nevada, as I believe that all of her ties are out of state at this point. Thank you.
Trent?
Thank you, Your Honor. As is clear from, I think, the probable cause sheet, Ms. Henderson is struggling with her substance use disorder. She is asking for this opportunity to go to an inpatient program. So our request would be for direct transport from the jail to a program as indicated by an evaluation, likely an inpatient residential, again, as indicated by a substance use evaluation.
So I've already written that down. I agree with you. It is the only way to minimize the risk she poses. With an individual that scores a higher risk to reoffend or fail to appear, puts them in the 50th percentile of being successful. And then if we look at the class of charges that are most likely to reoffend or fail to appear, it's drug charges. The only way to minimize that risk would be to release her to residential treatment if, as Ms. Raines points out, the evaluation recommends that level of treatment. Then I'd allow her to be released with IEP direct transport on her own recognizance to the treatment center. If not, then the bail is going to be the $15,000 as recommended by the state, because they've shown by clear and convincing evidence that's necessary to ensure the safety of the community appears to the defendant will include random drug testing and DAS supervision. Bail allows make court appearances November 7th at 9 a.m. is the next court date. Proceed back then. Himmers and then Matt.
In your similar request for Mr. Hinmers, I was able to speak with him. I'm asking to waive his appearance due to his detoxing this morning.
All right. Would Steve feels appropriate on this matter?
Yes, Your Honor. In this case, we are asking for $10,000 DAS supervision testing for alcohol and controlled substances. Defendant scores a 12, has criminal history going back to 2010, where he had a felony conviction for possession of a controlled substance in California, a 2011 DUI conviction, 2014 misdemeanor conviction for possession of drug paraphernalia, as well as a felony conviction for burglary and gross misdemeanor conviction for conspiracy to commit burglary. 2018 had a failure to comply arrest. 2019 had a child abuse case that was dismissed. Has in the early 20s a couple possession of drug paraphernalia cases, one of which 21 resulted in a conviction. Had a couple failures to appear also in 2021, had another failure to appear in 2022, then had a misdemeanor conviction for domestic battery and disturbing the peace in Sparks Justice Court in 23, and then already has a possession of drug paraphernalia conviction this year in Sparks Justice Court. And so based upon the lengthy history with substance abuse, the recent failures to appear, we believe he's a risk to the community, risk not to appear, and ask that you set bail. Thank you.
Thank you, Ms. Rains.
Thank you, Your Honor. And it's similar to the last case, Mr. Hinmers is likewise really struggling with his substance use disorder. He indicated that he feels ready to go to a program, and so we would ask for an alternative to the bail to be a direct transport should an evaluation recommend residential or inpatient treatment. He wants to take advantage of that he's already going through the withdrawals at this time, and so then could be in a position to be clear-headed to begin treatment when that's, should that be available to him.
All right, same findings and ruling as the previous case, $10,000 bail, random drug testing of bail laws, make a court appearances, DA supervision, award residential treatment if eval recommends that level with IAP transport. November 7th, 9 a.m. Thank you. Matt and then Whiteman. What does the state feel is appropriate on this matter?
Yes, Your Honor. In this case, we are asking for $20,000 DAS supervision, testing for alcohol controlled substances, no possession of firearms, as well as no contact with 1095 East 4th, the Fantasy Girls. Your Honor, the defendant has history going back to 2020. Concerningly, he had a reckless driving conviction that was down from a DUI in Reno Municipal Court in that year. Had a 2022 arrest for battery that was dismissed, obviously concerning given the discharging of the firearm here. And then a 2023 careless driving. Again, as the PC notes, he was a 0.153 when this occurred, concerning given the kind of thought that appears to have gone into this, where he returned to the vehicle, was on video getting the firearm, returned to the establishment where he was turned away, and then got in the argument, discharged the firearm. So concerning given the alcohol and firearms involved here, and based upon that and the prior DUI case that was pled down with the DUI here, we believe is a risk to the community, and therefore believe that bail and conditions of supervision are appropriate. Thank you.
Thank you, defense.
Thank you, Your Honor. We were trying to reach my client's wife this morning. Unfortunately, we were not able to speak with her. As is indicated in the pretrial interview, he does have an address in Sparks. He has a phone number. He's a business owner. Clearly, alcohol was at play in this event, as well as his criminal history. The risk to the community could be mitigated by enforcing no alcohol for Mr. Matt, which he would comply with, that he could be supervised by the Department of Alternative Sentencing. He is prepared to surrender all firearms, and with that level of supervision, that would be the least restrictive option for the court today. And so we're asking for that, an own recognizance release, no alcohol, testing, no firearms, and making arrangements to surrender firearms within a short time after release.
All right, thank you. The state shown by clear and convincing evidence that bail outside the defensibility make it is necessary to ensure the safety and community appearance of the defendant. A set of $15,000, no contact with Fantasy Girls location. Random drug testing, day-to-day alcohol testing, no firearms, DA supervision, no bail laws, make all court appearances November 7th at 9 a.m. is the defendant's next court date. We'll see you back then, sir. Whiteman and then Bennett. What the state feels appropriate on this matter?
Yes, Your Honor. In this case, we are asking for $2,500 bail DAS supervision and testing for alcohol and controlled substances. She had, as the court may know, a failure to appear, failure to comply out of Reno Municipal Court. Has a criminal history going back a number of years, had 2018 obtaining money by false pretenses that I don't show disposition for. Had another arrest in 2011 with destruction of property that was ultimately dismissed. Defendant also has a history prior to that in California. Extremely concerningly, in 2003, she had well, it was a misdemeanor. It said DUI causing bodily injury. Also has an older failure to appear in a couple property crime arrests I don't show disposition for in the state of California. And so, again, it appears substance abuse has been an issue for a while for her. And given that she has that failure to appear, I couldn't tell what that was underlying at a Reno Municipal Court, but concerned that she will not appear and address this issue. So therefore, we believe that bail is appropriate. Thank you.
All right, guys.
Thank you, Your Honor. With regard to the Reno Municipal Court case, it looks like that was related to traffic offenses, and that has been satisfied as of this morning via cash payment with help from her son. So she's resolved that matter. In addition, the probable cause sheet had indicated that she had a warrant, and there's documentation at the jail showing that that has been dropped. So she's no longer being held on that. That leaves her only being held here on a possession of drug paraphernalia. And
Ms. Raines, I'm going to release her on her own consent.
okay, thank you, Your Honor.
Ms. Whiteman,
Yes,
do you have a cell phone?
yes,
Make sure we have your number. In fact, I'm going to order that you appear Monday in our court before noon. Make sure that you know where we're at. We have your cell phone number so we can text you reminders. If you have transportation issues, you can request to appear by Zoom or remotely from your phone. But it's really important you show up, because if not, I'm going to have to put you back in jail and set a bail you can't make. Okay?
yes, sir.
Right. This is a misdemeanor. It's going to be taken care of really easily if you just show up. So make sure you show up Monday. So I'm going to put that as your next court date. Actually, you have to be here Monday the 3rd. All right, before noon.
Thank you.
Where to go? Okay.
Raymond will be the 11th.
Thank you.
Reno Justice Court on Sierra Street. Reno Justice Court. Before noon on Monday.
No. Okay,
Oh, so yeah, you'll go back. Perfect. It'll be in your release.
all right, Bennett and then Heller.
Oh, that's right. Your Honor, Mr. Bennett is waiving his appearance. I'm prepared to go forward.
All right, what state feels appropriate on this man?
Yes, sir. In this case, we're asking for $10,000. The defendant has NPRA score of 8, has older criminal history. Concerningly, he's got the fugitive from another jurisdiction matter. Has older history from the 80s into the early 2000s in Arizona. It appears to be mostly misdemeanor property crimes. His criminal history in Nevada appears to start in 2019, where he had a misdemeanor conviction for violating a domestic violence TPO in Sparks Justice Court, as well as a misdemeanor conviction for domestic battery. 2020 had a misdemeanor conviction for destruction of property here in Reno Justice Court, as well as a misdemeanor conviction for petty larceny. Given the out-of-state issues, as well as the prior, again, violating the TPO in the state's view, that indicates that he would not be likely to comply. We'd ask for DAS supervision as well, so that if he makes bail and has to address other issues, that we are aware of where he is at. Thank you.
Ms. Raines.
Thank you. On behalf of Mr. Bennett, he lacks financial resources to post any amount of bail based on his inability to pay. We would request an owner cognizance release.
So I'm sorry, what's he in custody for already?
So I show that he has a fugitive complaint.
California bail $25,000. I see that.
Yes.
But what's the underlying offense? Do we know?
Fire, possess, or receive stolen property. Oh, for the fugitive. Grand theft for the fugitive.
I'm sorry, you said it's.
Grand theft on the fugitive now.
Grand
Yeah.
theft's what I heard, right?
Yes, yes, that's what
Okay, thank you.
Deputy Ellis is reporting.
Thank you, Deputy Ellis. All right. Well, then the state shown by clear and convincing evidence that bail is necessary to ensure the safety of the community and the appearance of the defendant set at $10,000. Obey all laws, make all court appearances. DAS supervision. Next court date will be the 7th of this month at 9 a.m. All right, Heller and then Lenny.
Your Honor, just as Mr. Heller's making his way up here, he does intend to retain private counsel.
Morning, Mr. Heller.
Morning.
When do you plan on retaining counsel?
As soon as possible. I have not been able to contact my wife on the matter.
So you have two options today. You can go forward and represent yourself on this bail hearing, or you
Okay.
can wait till you get an attorney to represent you.
Okay, I can represent myself then.
All right. What's Steve feels appropriate?
Yes, Your Honor. So regarding Mr. Heller, we are asking for $20,000 bondable. I understand the defendant has no criminal history and has an NPRA of 0. However, what is concerning beyond the facts of this incident specifically is also the how it's outlined in the PC that this has been an ongoing issue. We did speak with Mr. Hartman. He indicated that he does not want to be present today. He indicated he just wants the defendant to stay away from him and his family. He indicated that he and his family are very afraid that the defendant has caused a number of instances already, that they live in the same neighborhood, that he has harassed his wife and stopped her from driving down the road, accusing her of speeding. So it is clear that whatever is going on here in this neighborhood dispute, it is escalating now. Obviously, it was quoted in PC. Mr. Hartman's son was with him when this occurred. And so in addition to the bail, we are asking for DAS supervision. I believe that there was a number of firearms taken. We would ask that with the DAS supervision, if there are any other firearms, that they be turned over to DAS pending that he have no firearms, and that he not contact Mr. Hartman or his family at the 26 and stay away from the 2655 Sequoia Lane address. Thank you.
So, Mr. Heller, you've been there for a bit this morning. You see that we don't really, you heard the state mention the facts of the case, but that's not what the defense addresses, right? You haven't heard Ms. Raines, the public defender, really talk about the facts of the case. She talks about an individual's prior criminal history, whether they're likely to show up, what ties they have to the community, those sorts of things. You really don't want to talk about the facts of the case. Today is not the day to do that for you. If
Precisely.
you do, we are recording what you are saying, and it will absolutely be used against you, whatever you say with regards to the facts, whether you think you're saying the right thing or not. I saw you didn't talk to the police. You obviously know that you have the Fifth Amendment right not to incriminate yourself. So I'm just strongly advising you to not say anything with regards to the facts of the case so that you don't incriminate yourself.
Okay.
Is there anything outside the facts of the case you'd like to talk about?
I would be glad to surrender firearms or move them from my house, provided bail is appropriate.
And
I would be happy to stay away from the accuser.
okay. I assume, based upon your statements, that you are going to hire your own attorney based on the car that you're driving in the incident, allegedly. You have the ability to post the bail that the state indicated, because we allow we follow the best practices from the American Bar Association. We allow you to post 10% of the bail by cash or credit card. So
Okay.
$2,000 on a credit card gets you out of jail. Is that something you're gonna be able to make?
I believe I can do that. Yes, sir.
All right. So then I'll simply just follow what the state's recommended. You've agreed to follow those conditions, $20,000 bail or 10% cash, no contact with the victims, no firearms, checking with DA's order, no bail laws, make no court appearances. Your next court appearance will be 11/11
Okay.
at 9 a.m. Make sure we have your good cell phone number at our court so that you get text reminders of your court appearances, okay?
And Your Honor, if I could just interject, I believe 11/11 is a holiday, so
Oh, you're right. That Tuesday is a holiday. Good job, Ms. Raines. The 10th will be the arraignment. Monday. A week from Monday. Thank you. All right, good luck to you, Mr. Howell. Thank you. Lenny and then Parks.
And Your Honor, I believe that we do have the victim on Lenny.
We do. All right, what states feel is appropriate on this matter?
Yes, Your Honor, in this case, we are asking for $15,000 bondable, given it's a crime against a individual. I understand it's category C, but again, we're asking for bondable. DAS supervision, no weapons. I would note that we spoke with the victim, Jaden Linney. It's my understanding that he does not want a no contact order and he's not afraid for his safety. And so I would defer to him at the appropriate time later. Concerningly for Mr. Christopher Linney, he's got criminal history going back 2006. I show a DUI with no disposition in that year, a 2014 misdemeanor conviction for DUI. Probably most concerningly in this case is he had a 2017 case that was a disturbing the peace conviction. Originally, it had been an allegation of domestic battery and child abuse against his wife and daughter. Looks like it was pled to that lesser. 2023, he had a felony conviction for possession of a controlled substance, 14 to 28 grams in the second judicial. Looks like he was arrested for a failure to appear during the pendency of that case. And then in 2024, he had a misdemeanor conviction for false statement obstructing in Sparks Municipal Court. So given that Mr. Linney has a number of issues in his past, including concerningly an apparent incident of family violence previously. And here we have a indication of further violence with essentially an independent witness that corroborates the events. We believe there's a risk to the community and believe that bail is appropriate. If I didn't already ask, DAS supervision and no weapons given the allegations of violence. Thank you.
I thank you, Ms. Raines.
Thank you, Your Honor. We did reach Mr. Linney's reference this morning to verify his employment, which he was given a point for on the MPRA assessment. We also verified his residence. He resides at the Terrace Drive, but could stay at an alternative location. He is working and could support himself to be in another location should the court so order. That would bring his risk score down into the low category, rather than he's at a moderate right now at a 5. Understanding he has had some legal issues in the past. However, recently he's maintaining his residence, his employment, and it's our understanding that the alleged victim, his son, is supportive of Mr. Linney, although certainly he can provide that information on his own behalf. With that, Your Honor, we would ask for an own recognizance relief, and the court can order check-ins with the Department of Alternative Sentencing to make sure he attends future court appearances.
All right, Jaden Linney, if you want to unmute yourself and go ahead and let me know what your thoughts are.
Hello, can you hear me?
I can.
Alrighty. My thoughts on exactly what do you want to hear?
on whether he should be released, any concerns you have?
I have no concerns. It was a fight that got a little unhand. Sometimes that happens when people get frustrated. I love my dad to death. I want to see him do good. That's the whole reason why I had him move in with me. And I would love for him to get out. I basically, in my mind, I took it as the holding cell would clear his mind a little bit of the frustration and help him see what it was like again. And basically, yeah, so he doesn't want to go back, and he has a clear state of mind that he wants to stay out of jail again.
Is there anything he needs to help him stay out? Does he have a problem with drugs or alcohol or anything like that?
Negative, not that I know of.
Okay. All right, thank you so much for being here. I will release him based on your statements and his low risk score on his own recognizance. I'm not going to allow him to possess any firearms. He'll have to obey all laws, make all court appearances, check in with DS as ordered. November 10th at 9 a.m. will be his next court date. Thank you so much. Good luck to both of you.
Thank you,
All right,
Judge.
thank you. Have a good night.
Perks and then Schaefer. I would see if it was appropriate.
Yes, sir. In this case, we are asking for $10,000 DAS supervision, testing for alcohol and controlled substances. The defendant has a criminal history going back to 2011. He had his criminal history seems to show a domestic battery conviction, although in Odyssey it indicates that it was a simple battery. He had a 2021 misdemeanor conviction for DUI. That's the underlying concern here as far as a second. And then he had an arrest in 2024 for failure to appear, which is concerning for failing to appear. In that year, he had a possession of a firearm by a prohibited person arrest. However, again, when our office confirmed the simple battery, then that was dismissed. But again, given the relative short order of this newer misdemeanor conviction, as well as his failure to appear last year, that was in July, we believe that he's a risk not to appear, a risk to continue this substance abuse and driving, putting the community at risk, as well as obviously the child endangerment in this case. So we believe that bail is appropriate and ask that you impose it. Thank you.
Great.
Thank you, Your Honor. We were able to speak to Mr. Perk's reference this morning to verify information. We verified his address, that he's been at that address in Silver Springs for a year. He is also working full-time, which we verified. He'd started at that employment through Manpower and had been temporary for about 6 months, was just hired full-time at the same place. He's scheduled to work tonight and is hoping to make it to that shift. It's a good job now that he's full-time, has benefits, insurance. We spoke to his landlord again to verify his residence. With that information, that would reduce the MPRA score by 3 points. Also, we verified his phone number, so it would it would reduce his score by 4 points. Clearly, as indicated by the probable cause sheet, alcohol is a concern for Mr. Perks. With monitoring for alcohol and abstaining from alcohol, that would minimize his risk to the community. He is building stability. That failure to appear was about a year ago. Again, he's maintained a job, maintained a residence, and so is more likely to attend future court appearances regarding this matter. We're requesting an own recognizance release, again, with the alcohol supervision to mitigate any risks to the community and ongoing criminal activity.
The defendant poses a high risk to the community with regards to his repeated impaired driving. if you're gonna be killed by a stranger in this country, it's gonna be by an impaired driver, statistically. However, while I have DAS and the 24/7 program, the science is that we can effectively mitigate that risk. In fact, reduce it by at least 50%, according to the studies with regards to 24/7 programs. So while it appears I'll at least have DAS for the next month or two, I'll go ahead and release him because I believe I'm constitutionally compelled to do so, given the ability to reduce that risk. Own recognizance release, random drug testing, daily alcohol testing. He'll do a DUI rant. He'll do daily mutual support group meetings until in treatment. DAS supervision, obey laws, and I go court appearances. November 10th at 9 a.m. is the defendant's next court date. We'll see you back now. Schaefer and then Verana.
It'll be on your release paperwork.
What state feels appropriate on this matter?
Yes, Your Honor. In this case, we're asking for $15,000 DAS supervision, testing for alcohol and controlled substances. The defendant has criminal history, primarily out of state. I don't show any Nevada history. The defendant has history going back to 1998 with a felony conviction in Vancouver, Washington. Also concerningly had a felony conviction for robbery in 2002, a felony conviction for assault, domestic violence in 2016. Again, these are Washington cases. 2019 felony conviction for assault in Vancouver, Washington. The most recent case I show is a DUI arrest in Ridgefield, Washington, with no disposition. So given his lack of ties to the community, multiple prior felonies, as well as his what appears to be an outstanding DUI case in Washington, and the fentanyl subject here, we believe he's a risk to the community, risk not to appear given lack of ties to the community, and ask that you impose the $15,000 as well as the supervision and testing. Thank you.
Ms. Raines.
Thank you, Your Honor. Mr. Schaefer does have ties to our community. He moved here recently from Washington State. However, he moved here in order to live with his father and stepmother. And so he has those family ties here. That's the address on Peppermint that he provided. We spoke with his father this morning, who verified that Mr. Schaefer is in fact residing with him, that he's been here for a couple of weeks, that he moved here from Vancouver, Washington, and that he is working for SK Foods and has been working there since he moved to the area. So although his ties to other states are prominent, he has recently again relocated to this area for family support. That's where he would return, and that's where he would be able to receive messages in order to stay in contact with a supervising agency, as well as the court. He would appear for future court dates with the condition of no controlled substances and testing for the same. Then that would be the least restrictive option before the court today, to grant an OR with those conditions.
Mr. Schaefer, what sort of treatment have you done before?
I've done out or inpatient treatment, and I just finished 2 years of outpatient treatment to get deferred prosecution on that DUI, so I wouldn't be convicted of it. So
have you done medically assisted treatment before for opiates, fentanyl? Have you done methadone, Suboxone, anything like that before?
So opiates, that's not my thing. I don't do those.
Oh, okay. I thought that was involved in this case. I thought there
was. I think they think that.
Okay. All right.
Adderall. It was Adderall that I was holding on to my brother because he had no pockets. And they were prescribed.
All right, hold on. Don't talk about the facts of the case. I just had read they thought that people were overdosing and fentanyl responded. So I'll release you if you get back to the treatment.
Okay.
Does that seem fair?
Sure. Yeah.
All right. So I'll release you on your own recognizance, random drug and alcohol testing. You get back enrolled within 7 days. If you can do that remotely with your previous provider, a lot of providers will take you back. Oftentimes for free, your previous treatment providers. But you need to be enrolled in treatment within 7 days. DA supervision, will bail laws, make all court appearances. November 10th at 9 a.m. for your next court date. Thank you.
All right, thanks.
Verana?
And Your Honor, I'd ask to waive Mr. Varana's appearance. I think that we may be having some SB 89 issues, so my request is going to be for an interim order.
All right, since you believe you have SB 89 issues, I'll go ahead and appoint you despite the fact that the defendant didn't complete the process for application. I think the law allows me in the circumstance to appoint the public defender. I'll do so. And then what's the interim bail the state would like while we address any SB 89 issues?
Yes, Your Honor, we're asking for 5,000 DAS supervision and testing.
All right, that'll be the order. And when do you want to come back, Ms. Raines?
Your Honor, we could see, well, if we set the 72.
All right, I'll do it. November 7th would be the next 72-hour date, 9 a.m. All right, that just leaves us with the fugitive matter. Do we have Mr. Ford?
Oh,
Oh, he's the same individual we saw earlier that we saw bail on. He just used a different name. That's my recollection. Is it? He was the person that had the California $25,000 warrant, right?
No, this is different, Your Honor. That was
Oh, okay.
Mr. Bennett, I believe, was before.
Right, I thought he had a different name. No, all right. But he used a different name on that. Anyway, do we have Mr. Ford?
You waived his appearance.
he waived his appearance, Your Honor.
All right, then we'll, the bails remain the same. We'll see him back on the 7th. Let me just make sure I'm not making a mistake. So, rest fugitive on Bennett. You're right. I'm wrong. All right, bail remain as said on Mr. Ford. We'll see him back when we get the fugitive complaint, not later than the 7th at 9 a.m.